योगः कर्मसु कौशलम्।
सबसे पहले मैं धन्यवाद देना चाहता हूं गुजरात यूनिवर्सिटी के यूजीसी एचआरडीसी सेंटर को, जो कि बहुत ही रेलेवेंट इशू इवेल्युएटिंग लॉ एंड पॉलिसी इन इंडिया फ्रॉम द लेंस ऑफ 21st सेंचुरी पर ये कार्यशाला जो एफडीपी आयोजित कर रहे हैं। मैं इसमें सभी को बधाई देना चाहता हूं और खास तौर से डॉक्टर भावेश भरत सर को। मैं उनके परसिवरेंस को पिछले 3 महीने से मैं ऑब्जर्व कर रहा हूँ कि किस हिसाब से वो एक अपनी कठिन मेहनत से और एक एक स्पीकर के पीछे किस हिसाब से उन्होंने फॉलो अप करके रिकॉर्डिंग और सब चीज को आयोजित करवाने में मदद कर रहे हैं। मेरा जो टॉपिक है वो क्रिमिनल जस्टिस एडमिनिस्ट्रेशन इन कंटेम्प्रेरी सिनेरियो है। बेसिकली जो क्रिमिनल जस्टिस सिस्टम है, एक आजकल के युग में ये जो टॉपिक है, आई थिंक एक सबसे महत्वपूर्ण टॉपिक्स में आता है, जो कि आम व्यक्ति की फंडामेंटल राइट, आम व्यक्ति का जो अधिकार है, इस हिसाब से एक पुलिस की एट्रोसिटीज, पुलिस को अगर देखा जाए तो एट्रोसिटीज करने की संभावनाएं बहुत ज्यादा होती हैं। हाउ द पुलिस कैन टेक एविडेंसेस and put the common people in the trouble, that is a very important thing. Now सबसे पहले मैं स्टार्ट करूंगा, अगर आप क्रिमिनल जस्टिस एडमिनिस्ट्रेशन की हिस्ट्री के पर्सपेक्टिव से देखेंगे, क्रिमिनल जस्टिस एडमिनिस्ट्रेशन में, ठीक है, स्पेसिफिक लॉज आजकल के समय में आ रहे हैं, फूड एडल्ट्रेशन एक्ट, प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट, जैसे जैसे युग आगे बढ़ता जाएगा वैसे वैसे नए नए लॉज की डायनेमिक्स भी आती रहेंगी। ठीक है, लॉ एंड सोसाइटी बोथ रन्स टुगेदर। बट यहाँ जब आप हिस्टोरिकल बैकग्राउंड पे जाएंगे लॉ के, तो एक सबसे इंपॉर्टेंट इशू ये है कि खास तौर से क्रिमिनल जस्टिस एडमिनिस्ट्रेशन में जो हमारे 3 मेजर लॉज हैं, जिसमें कि इंडियन पेनल कोड, इंडियन एविडेंस एक्ट और क्रिमिनल प्रोसीजर कोड, तीनों आते हैं। ठीक है, सीआरपीसी हमारा भारत में आजादी के बाद अमेंडमेंट हुआ और वही एक कोड के रूप में चल रहा है। और सीआरपी की अगर सीआरपीसी की अच्छाई देखी जाए तो क्रिमिनल प्रोसीजर कोड की सबसे बड़ी खासियत यह है, इट हैज टेकन इनटू कंसिडरेशन द इंटरेस्ट ऑफ एवरी सेक्शन ऑफ द सोसाइटी। अगर आप ऑब्जर्व करें, एक कॉमन पीपल के इंटरेस्ट की बात करता है, पुलिस को भी राइट दिया है, पुलिस को भी पावर दिया है, पुलिस के ऊपर भी लगाम भी रखा है, और जुडिशरी को भी पावर दिया है, जुडिशरी के ऊपर भी रेस्ट्रिक्शन दिया हुआ है। You can see from section 154 to section 173 कैसे एक पुलिस को इन्वेस्टिगेशन में एक पावर दिया गया है, कैसे उनकी इंडिपेंडेंस को भी ध्यान में रखा गया है, कैसे ये भी कहा गया है कि सेक्शन 159 में कि जुडिशरी की सुपरवाइजरी पावर है, बट जुडिशरी कैन नॉट इंटरवीन इन द इन्वेस्टिगेशन पावर ऑफ द पुलिस। लेकिन वो 173 के बाद सारा पावर जैसे ही पुलिस रिपोर्ट सबमिट हो जाता है, देन द पावर ऑफ द judiciary comes into the picture. How the role of the judiciary comes into the picture? Power तो मैं नहीं कहूँगा, role of the judiciary comes into the picture. And most important thing is that how the separation of power is the basic structure of the constitution. We can prove it from the criminal procedure code also. Legislature ने कोड बना दिया, लेजिस्लेचर ने कोड बनाने के बाद हमारी जो एग्जीक्यूटिव मशीनरी है वो कैसे इन्वेस्टिगेशन करती है, एंड हाउ after submitting the police report before the magistrate, how the role of the judiciary comes into the picture. एक separation of power is the basic structure, basic feature of the constitution. ये हमारे सीआरपीसी से भी प्रूफ होता है। इंडियन एविडेंस एक्ट पे जाएं, इंडियन एविडेंस एक्ट की एक सबसे बड़ी खासियत अगर आप देखें तो ये प्रिज्यूम किया गया है कि पुलिस कैन यूज atrocities, police can misuse their power. This is the reason confession before police officer does not amount to be a confession. सीआरपीसी में यही बात ध्यान में रखी गई है कोडिफिकेशन के समय में, और एविडेंस में भी यही बात ध्यान में रखी गई है। तो कैसे इंडियन पेनल कोड, क्रिमिनल प्रोसीजर कोड और एविडेंस एक्ट, ये तीनों जो कानून है कैसे एक दूसरे के पूरक हैं, कैसे एक दूसरे के कॉम्प्लीमेंट टू ईच अदर हैं, ये हमें ध्यान रखने की जरूरत है। अब हम इंडियन पेनल कोड की बात करते हैं। अगर आईपीसी की अगर आप हिस्टोरिकल बैकग्राउंड पे जाएं, आईपीसी को बनाया अंग्रेजों ने था, और आईपीसी को अंग्रेजों ने 1857 के बाद लाया। ठीक है, इसकी रूपरेखा तो बहुत पहले से चल रही थी। एक किसी की भी कानून को लाने में 1-2 वर्ष तो नहीं लगते हैं, मिनिमम आपका उस पर डिस्कशन, और खास तौर से इंडियन पेनल कोड जैसे कानून पे उसकी रूपरेखा बहुत पहले से तैयार हो रही थी। लेकिन 1857 के रिवोल्ट के बाद से अंग्रेजों को लगा कि देयर शुड बी सम लॉ इन ऑर्डर टू कंट्रोल द इंडियंस, क्योंकि रिवोल्ट के बाद उनको एक धक्का लगा था। उन्होंने कभी ऐसी उम्मीद नहीं की थी। ठीक है, उसके पहले भी बहुत से आंदोलन हुए, हम लोग 1857 को याद रखते हैं, लेकिन उसके पहले भी हमारी हिस्ट्री में बहुत सी ऐसी घटनाएं, बहुत से हमारे स्वतंत्रता संग्रामी लोग थे जिनको हम लोग मिस करते हैं। लेकिन अगर आप आईपीसी को ध्यान में रखते हुए अगर आप स्टडी करेंगे तो बेसिकली जो मेनली 3 प्रोविजन है, सेक्शन 34 ऑफ द इंडियन पेनल कोड जो आपकी कॉमन इंटेंशन की बात करता है, सेक्शन 149 जो आपकी कॉमन ऑब्जेक्ट की बात करता है, देन सेक्शन 120 की जो क्रिमिनल कॉन्स्पिरेसी की बात करता है। ये जो तीनों प्रोविजन है, इन तीनों प्रोविजन ने एक शासन को, चाहे वो प्रेजेंट सिनेरियो में भी शासन हो, चाहे वो पुलिस की जो मिसयूज ऑफ देयर पावर एंड पावर, हम यहाँ पर पावर एंड मिसयूज ऑफ पावर दोनों की बात कर रहे हैं, अगर उसको देखें तो इन्हीं तीनों प्रोविजन का बहुत बड़ा योगदान है। अब यहाँ पर एक इश्यू आता है कि ये जो तीनों प्रोविजन है, ये तीनों प्रोविजन अंग्रेजों के द्वारा ही लाया गया था, और आज भी हम इन्हीं प्रोविजन के द्वारा अपने कानून व्यवस्था को रन कर रहे हैं। ठीक है, पुलिस की जो भी पावर है, अगर आप पुलिस सिस्टम को समझते हैं, कोई भी हमारे एकेडमिशियन लोग हैं जो कि इस क्लास में फैकल्टी डेवलपमेंट प्रोग्राम में हैं, मैं ख्याल से आप इस चीज को अप्रिशिएट करेंगे कि कैसे इन तीनों प्रोविजन का एक पुलिस की पावर में बहुत बड़ा योगदान है। किसी को भी अगर आपको और खास तौर से इन्वेस्टिगेशन में जो पावर, तो ये हमारा आईपीसी, सीआरपीसी और इंडियन एविडेंस एक्ट का एक ब्रीफ वर्णन हुआ। एविडेंस एक्ट जो बोथ सब्सटेंटिव एंड प्रोसीजर लॉज हैं, आईपीसी प्योरली सब्सटेंटिव लॉ है जो आपकी राइट एंड ऑब्लिगेशन एंड लाइबिलिटीज को डिफाइन करता है, लेट डाउन करता है कि कौन कौन से प्रोविजन है, कौन कौन से ऑफेंसेस हैं, और ठीक है उसमें पनिशमेंट भी दिया हुआ है। पनिशमेंट के बेसिस पे हम ये भी एग्जामिन करते हैं कि ये नॉन बेलेबल है, बेलेबल है, कॉग्निजेबल है, नॉन कॉग्निजेबल है, कंपाउंडेबल है, नॉन कंपाउंडेबल है, ये सारी चीजें। अब एक तो ये चीज क्लियर हो गई कि जो अंग्रेजों ने कानून बनाया था वही कानून आज आईपीसी में हम उसी पर हम आधारित होकर के आगे बढ़ रहे हैं। एविडेंस भी वही है, कुछ प्रोविजंस होते रहते हैं डे टू डे, जैसे आईटी एक्ट में हुआ, मे प्रिज्यूम, शैल प्रिज्यूम के कॉन्सेप्ट में चेंजेस हुए। लेकिन क्रिमिनल प्रोसीजर कोड जो कि मैंने आपको बताया है, ये क्रिमिनल एडमिनिस्ट्रेशन का सबसे आपका मोस्ट इम्पोर्टेंट पार्ट है, उसमें जो सबसे इम्पोर्टेंट इश्यूज हैं क्रिमिनल एडमिनिस्ट्रेशन का, जो कि यहाँ पर सबसे पहले ही वाली बात करता है कि हाउ द प्रिंसिपल फीचर ऑफ फेयर ट्रायल, that is the skeleton of the of our justice delivery system, and therefore I will try to discuss from these the principal feature of fair trial. देखिए, उसके पहले मैं बताना चाहूंगा जो हमारा एडवर्सरियल सिस्टम है, where both the parties they are adversaries to each other, and on judges, whether lower court or high court, whether lower court, session court, high court or supreme court, जो भी judges हैं, they have to pronounce the judgment on the basis of equity, justice, and good conscience. But in the adversarial system, India has adopted the adversarial system where they have given prerogative to both the parties. They can put their views, they can through their advocate, they can put their statement before the court of law. And India has basically not adopted the inquisitorial justice delivery system, where in the inquisitorial justice delivery system, it is based on the inquisitiveness of the judges, where if judge have any kind of queries, if a judge have any questions, if judge have any observation, they can put before the court of law. Therefore, important thing is that in the case of inquisitorial justice delivery system, European countries have adopted this system. But in India, there are some provision like section 313 of the CRPC, where it provides for the examination of the accused. Then section 315 of the CRPC, where it provides for the competency of the accused. Then section 165 of the Indian Evidence Act, where it provides that court can ask any question in order to satisfy himself. These are the basically some provision. Otherwise, in India, we have adopted adversarial justice delivery system, and that is the very important feature of our justice delivery system. Then, second principle is that presumption of innocence. That is the important thing. In the presumption of innocence, a person should be presumed to be innocent unless and until court pronounced him as a guilty. That is the important thing. A person should be presumed to be innocent. And in the presumption of innocence, even in the principle of our bail, basic rule is that bail is a rule and jail is an exception. Important thing is that in the case of bail, it is based on the whenever we are reading the concept of presumption of innocence, where we ought to presume that a person is presumed to be innocent unless and until court pronounce him as guilty. This is the presumption of innocence, the concept of presumption of innocence, where prosecution is bound to presume that the person who is called as accused is innocent unless and until court pronounce him as a guilty. Where other basic principle of criminal jurisprudence is proving prosecution is bound to prove the guilty beyond reasonable doubt, and this is the other principle where prosecution have to prove the case, and that there should be beyond reasonable doubt. Even if there is any doubt, accused will get the benefit of accused will get the benefit under the benefit of doubt. Now, important thing is that which I just want to discuss in the principal feature of fair trial. On the one hand, you are presuming that that we are bound to presume that the person is innocent unless and until court pronounce him as a guilty. And on the other hand, you have to prove the case beyond reasonable doubt. But suppose we are putting that person in jail, and if we are endeavor and if we are determined to put that person in jail till the conclusion of the trial, uh, this is antithesis to our criminal jurisprudence. This is the reason uh, we have adopted the middle path. Now the bail is a rule and jail is an exception. And therefore, these two principles are very relevant in our criminal jurisprudence, and therefore, I have just shared these two principles. Then, other principles of features of fair trial, that is independent, impartial, and competent judges. These three words are three different words. There should be independence of judiciary, and there should be impartiality on the part of the judges also, and the judges should be competent. And this is the reason, even in the case of bail, you can see even in the case of non-bailable offense and in the case of anticipatory bail, judges have got the discretionary power, and it is based on the the gravity of the offenses and the punishment. If the punishment is at the highest level, the judge have got uh, your discretion is basically proportionate to the gravity of the offenses as well. Therefore, one this features of fair trial, that independent, impartial, and competent judges. It is one of the most important principles where we have to keep in our mind that judges are bound to give the judgment on the basis of their reasoning. This is the reason why arbiter dicta is playing a very important role. And important thing is that how the judges are able to satisfy their own judgment. It is equally playing a very important role. Therefore, independent, impartial, and competent judges. Impartiality means there should not be any kind of biasness on the part of the judges. They should put both the parties at the equal footing. They have to pronounce the judgment on the basis of equity, justice, and good conscience. They have to adopt the principle of natural justice, but they have to adopt the principle of audi alteram partem, and all the principles of even natural justice should be applied. Then, another feature of fair trial is that right of an accused to know the accusation, including framing of clear and unambiguous charges. Right of an accused and right of the arrested person it should be protected because they are very vulnerable. They are even I consider them as the most vulnerable person of the society because society is also against them, and police have got this opportunity to put any kind of atrocities with them, and judges can play very advocates they can play a very instrumental role in order to protect their own right. I am not talking in favor of them because in order to emancipate this country, in order to transform this country from the developing to the developed economy, we need peaceful society. And for the peaceful society, there should be our law and order should be maintained. But I have seen, even I have personally seen being a teacher of the criminal law, and I have observed that police have got opportunity to put any kind of atrocities, to induce them, to put any kind of threat against them. It is very easy for the police to take the confession, although the confession before police officer does not amount to a confession. But it is very easy for the police to influence the society also, and you can appreciate, you can observe this thing. Then other principle of feature of fair trial is that evidence to be taken in presence of the accused and his right to cross-examine prosecution witnesses and to produce evidences in defense. This is the important thing. that evidence to be taken in the presence of the accused, presence of the person. This is the other features of fair trial. Then right to expeditious trial, where the expeditious justice is the fundamental right of the common people, and basically in two cases, Husainara Khatun versus Union of India, and in the case of Sheila Burns versus Union of India, Supreme Court has specifically mentioned that right to speedy trial is the basic structure of the Constitution. Therefore, speedy justice, uh, I have realized that in the present scenario, Supreme Court and High Court, even the Ministry of Law and Justice, their endeavor uh, to promote the alternative dispute resolution system, where mediation, negotiation, conciliation, arbitration, and lok adalat, these are the forms of the alternative dispute resolution. Even sometime I have realized why the Supreme Court is promoting all these principles like mediation, negotiation, conciliation, because I think in order to impart expeditious justice, where this because in the case of mediation and conciliation and other form of alternative dispute resolution, it is based on the mutually satisfactory disposition, where the both the parties, if they are mutually satisfied, then they should go ahead. This is the reason, because in the adversarial justice system there are some lacunas where we cannot move ahead so fast. Uh, but in the case of ADR, we can move ahead in accordance to the mutually satisfaction of both the parties. Then a reasoned decision, judges are bound to give the reasoning of their decision. The judges have to specifically mention the arbiter dicta. Judges have to specifically, they have to uh, clearly discuss the reasoning uh, of their judgment, because there is a concept of appeal also. It is one of the most important aspects of our criminal justice delivery system, where other parties, aggrieved parties, they can opt for approaching to the appellate court, and finally, uh, it is the apex court which judgment is bound under Article 143 of the Constitution. Every courts are bound by the judgment pronounced by the Supreme Court. Therefore, these were the principles. Then other principle is that doctrine of atrofes acquit and atrofes convict, and it is given under section 300 of the Criminal Procedure Code and Article 20, where it provides that no one can be uh, prosecuted twice for the same offense. This is another very important principal feature of fair trial. Then last pre-sentence hearing in the serious cases. Therefore, I had discussed principal features of fair trial on which our criminal justice delivery system is based, and one other important feature in the case of Youth Bar Association versus Union of India, Supreme Court has specifically mentioned that it is compulsory on the part of state, on the part of executive machinery, uh, uh, to upload the FIR uh, online. In order, basic object is that common people should get to know that whether there any kind of FIR has been registered, FIR has been put against him or not. And if they could able to know that FIR has been registered, they will get this opportunity to move ahead in order to protect and in order to secure their right as well. These were the important issues which I had discussed. Then I had shared some important issues of, regarding the bail. But I just want to share why there should be the concept of bail. Bail is basically with respect to balancing the interest of the society, balancing the interest of the accused, as well as the balancing the interest of the both the societies, and in order to maintain the peace and harmony in the society, as well as in order to comply with both the basic feature of fair trial, that is, one is presumption of innocence, and other uh, is that prosecution is bound to prove the case beyond reasonable doubt. These are the things which I had discussed with respect to the bail. Then I would like to discuss the Victim Compensation Act. And in the case of victimology, that is a victim compensation law that is playing an important role. And even I would like to thanks to our legislature that they had broadened the horizon of the victim definition under section 2WA of the CRPC, where under section 2WA of the CRPC it provides that now the victim doesn't means the actual sufferer. It means it includes his or her guardian or legal heir also. This is the thing which we have to understand, that how our criminal justice system is developing day by day. You can see under section 2WA of the CRPC, victim, it is one of the most important aspects which we have to read from the victimology. That victim means a person who has suffered any loss or injury caused by a reason of the act or omission for which the accused person has been charged under the expression victim includes his or her guardian or legal heir. विक्टिम इंक्लूड्स हिज और हर। पहले क्या था, तो विक्टिम एक सोसाइटी का सबसे बड़ा सफरर होता था, सबसे बड़ा एग्रीड पर्सन होता था, जो कि वही अकेला पर्सन जो एक विक्टिम कहलाता था, जो क्राइम में सफर करता था, जो बेसिकली सफर होता था। आज की डेट में आप देखिए विक्टिम का थर्ड पार्टी इंश्योरेंस, ये जितनी भी इंश्योरेंस कंपनीज है, मोटर व्हीकल एक्ट में भी नो फॉल्ट लायबिलिटी का कॉन्सेप्ट है। देन दिस इज द बेस्ट थिंग इज दैट जो उसके ऊपर डिपेंडेंट है, एक्चुअल सफरर के ऊपर जो उसके डिपेंडेंट लोग हैं, उनको भी न्याय कैसे प्रोवाइड किया जा रहा है। दैट इज इवन ये एक जो वेलफेयर स्टेट का सबसे बड़ा एग्जांपल है कि हाउ इन आवर कंट्री द कॉन्सेप्ट ऑफ वेलफेयर स्टेट हैज बीन अप्लाइड एंड हैज बीन फॉलोड। We can see section 357A victim compensation scheme. Every state government in coordination with the central government shall prepare a scheme for providing funds for the purpose of compensation to the victim or his dependent who have suffered loss or injury as a result of the crime and who requires rehabilitation. आप देखो कितनी important चीज है, who requires rehabilitation. Then, whenever a recommendation is made by the court for compensation, the district legal services authority or the state legal services authority, as the case may be, shall decide the quantum of compensation to be awarded under the scheme referred to in subsection 1. They have used the word shall. They have not given any scope, any discretion to the other parties. They have made it compulsory, obligatory on the part of judges, that they have to comply the above principles. In the trial court, if the trial court at the conclusion of the trial is satisfied that the compensation awarded under the section 357 is not adequate for such rehabilitation, or where the case ends in acquittal or discharge and the victim has to be rehabilitated, it may take the recommendation for compensation. Fourth, where the offender is not traced or identified, but the victim is identified, and where no trial takes place, the victim or his dependent may make an application to the state or the district legal services authority for award of compensation. Fifth, on receipt of such recommendation or on the application under subsection 4, the state or district legal services authority shall, after due inquiry, award adequate compensation by completing the inquiry within 2 months. They have let down the time limit that they have to finish. They have to um, basically um, impart justice in such a specific period of time. Then, clause 6, the state or district legal services authority, as the case may be, to alleviate the suffering of the victim, may order for immediate first aid facilities or medical benefit to be made available free of cost on the certificate of the police officer, not below the rank of the officer in charge of the police station or a magistrate of the area concerned, or any other interim relief as the appropriate authority deems fit. Now, these are the things which we have discussed with respect to victim compensation. Now you can realize that how in our country the concept of victim compensation has been appreciated by our own legislature. This is the best thing. And now I would like to discuss. There is a concept of plea bargaining, where first of all I would like to discuss why there is a concept of plea bargaining. Um, One important thing is that our courts are already overburdened, and basically our apex court and government of India, they were introspecting from last so many years that how to lessen the burden of the court, and in order to fulfill the object of expeditious trial and expeditious justice, as well as to lessen the burden of court, they come up with the plea bargaining concept. But in India, the concept of plea bargaining is not so successful, and even Honorable Justice K.G. Balakrishnan have observed, and he answers very beautifully that why in India the concept of plea bargaining has not so successful. तो जब उनसे पूछा गया तो उन्होंने कहा कि इट इज द माइंडसेट ऑफ द कंट्री बेसिकली even I have personally realized that in India the concept of the command theory, that is the Austin theory, that we used to follow the dictate of the judges, but we cannot compromise with the on person with whom the dispute is going on. This is a kind of mindset in this country is going on, but we have to change this mindset also, and it can be changed after putting important things before them, that these are the suffering in the adversarial justice delivery system. But here important thing is that in the case of plea bargaining, it is based on the mutually satisfactory disposition of both the parties. Both the parties have to satisfy, and where victim will get the compensation, and accused accused will be benefited uh, after even suppose if there is punishment of 4 years, he will get the punishment of only 1 year, and but it is fully based on the mutually satisfactory disposition of both the parties. But important thing is that it is not so successful. And other issue is that one thing which we have discussed, that mindset of our own people. Then second thing is that if suppose accused have admitted that I am the person who have committed this crime, then the mindset of the judges, mindset of the prosecution, mindset of the police have changed with respect to that person who have committed that crime. This is also one important issue. Therefore, uh, this is the reason why people uh, why the accused are not accepted that they have committed the crime, because they know that even it is the duty of the court in the conclusion. Basically, court will decide who is the accused and who is basically victim. But here, important thing is that in the case of plea bargaining, if the accused admitted that he has committed that crime, then this is the mindset which is against that person. Therefore, we need to change these particular mindset. Uh, these were the reasons why in India plea bargaining is not so successful, although uh, it is in our it is in our CRPG from section 265A to section 265L. Then I would like to discuss one of the most leading case, which is mm, which came in the year 2013. This case is sorry, it came in the year 2014. This name of the case is Arnesh Kumar versus State of Bihar. This is I think it was pronounced by Chandramouli Kumar Prasad and Pinaki Chandra. One will discuss Pinaki Chandra and Chandramouli Prasad. Pinaki Chandra is now Lokpal of this country also. And Arnesh Kumar, I consider this case, Arnesh Kumar versus State of Bihar, as the most important case, which came in the year 2014 in the criminal appeal number 1277 and special leave petition criminal number 9127 of 2013. But in this particular case, Chanmoli Kumar Prasad, the petitioner, apprehended his arrest. Uh, his arrest in the case under section 498A of the IPC 1860 and section 4 of the Dowry Prohibition Act 1961. The maximum sentence provided under section 498A IPC is imprisonment for a term which may extend to 3 years and fine, whereas the maximum sentence provided under section 4 of the Dowry Prohibition Act is 2 years and with fine. एक समय था जब डॉरी प्रोहिबिशन एक्ट पे, ठीक है, अगर हम क्रिमिनल जस्टिस सिस्टम में देखें, इवन इन आईपीसी में अप टू द ईयर 1980 जो मथुरा रेप केस के बाद कैसे माइंडसेट चेंज हुआ, हाउ द माइंडसेट ऑफ द कॉमन पीपल हैव चेंज, हाउ द माइंडसेट ऑफ आवर जुडिशरी हैव चेंज. क्योंकि मथुरा रेप केस में जुडिशरी का जो क्रिटिसिज्म जो सबसे पहले स्टार्ट हुआ बाय ऑनरेबल बाय प्रोफेसर्स ऑफ यूनिवर्सिटी ऑफ दिल्ली, जिसमें कि there is an open letter to the Chief Justice of India, जिसमें कि इन्होंने क्रिटिसाइज किया कि how the judiciary has given favorable judgment to the police officer even they had committed rape in the police station, and the police got favorable judgment from the Honorable Supreme Court of India on the basis of passive consent on the part of the girl who was raped in the police station. And basically, I considered this case as one of the most leading case with respect to the change in the mindset of the judges with respect to the atrocities towards the women. And after the 1980, you will realize that so many amendment has taken place in IPC and CRPC and Evidence Act. You will realize that after 1980, so many amendment has taken place. And even with respect to the Dowry Prohibition Act, due to the change in the mindset of the judges, the mindset of the legislature had changed. Then mindset of the executive have changed. Then in all these, due to the mindset of due to the change in the mindset of all these people have realized that there was a change in the perception toward the woman with respect to the enforcement of the law. But we have seen. I had personally realized that there was misuse of the law with respect to the laws which are mainly women-centric laws. Even in the Dowry Prohibition Act, so many misuse were taken place In this particular case, Avnish Kumar case, Supreme Court has discussed this kind of misuse as well. Then petitioner happened to be the husband of respondent number 2, Shweta Kiran. The marriage between them was solemnized on 1st July 2007. His attempt to secure anticipatory bail has failed, and hence he has knocked the door of this court by way of this appeal, this special leave petition. Leave granted. In sum and substance, allegation leveled by the wife against the appellant is that demand of rupees 8 lakh, a Maruti car, an air-conditioned television set, etc., was made by her mother-in-law and father-in-law. And when this fact was brought to the appellant notice, he supported his mother and threatened to marry another woman. It has been alleged that she was driven out of the matrimonial home due to non-fulfillment of the demand of dowry. Denying these allegations, the appellant preferred an application for anticipatory bail, which was earlier rejected by the learned session judge and thereafter by the High Court. There is phenomenal increase in matrimonial dispute in recent years. The institution of the marriage is greatly revered in this country. Section 498A of the IPC was introduced with the avowed object to combat the menace of harassment to a woman at the hands of her husband and his relatives. The fact that Section 498A is a cognizable and non-criminal offense has lent it a dubious place of pride amongst the provisions that are used as a weapon rather than fielded by a disgruntled wife. The simplest way to harass is to get the husband and his relatives arrested under this provision. In a quite number of cases, bedridden grandfathers and grandmothers of the husband, their sisters living abroad for decades are arrested. Crime in India 2012 statistics published by National Crime Record Bureau, Ministry of Home Affairs, shows arrest of 1,97,762 persons all over India during the year 2012 for offences under Section 498A of the IPC, 9.4 more than the year 2011. Nearly a quarter of those arrested under this provision in 2012 were women, that is 47,951, which depicts that mother and sisters of the husband were liberally included in their arrest net. Its share is 6% out of the total person arrested and the crime committed under Indian Penal Code. It accounts for 4.5% of the total crimes committed under different section of the Penal Code, more than any other crime, excepting theft and hurt. The rate of the charge sheeting in cases under Section 498A IPC is as high as 93.6%, while the conviction rate is only 15%, which is lowest across all heads. As many as 3,72,706 cases are pending trial, of which on current estimate nearly 3,17,000 are likely to result in acquittal. Arrest, then I'd like to discuss we have discussed first how the misuse of this act has taken place. We can realize that 93.6% the rate of the charge sheeting in case under Section 498 IPC is as high as 93.6, while the conviction is only 15% people. We can see the atrocities of the common people. We can see the misuse of this law. We can see that how the common people were in the miserable position due to the misuse of this particular domestic Dowry Prohibition Act. But arrest which brings humiliation curtails freedom and casts scarce forever. Lawmakers knows it. So also the police. There is a battle between the lawmakers and the police, and it seems that police has not learned its lesson. The lesson implicit and embodied in the CRPC. It has not come out of its colonial image despite 6 decades of independence. It is largely considered as a tool of harassment, oppression, and surely not considered a friend of public. The need for caution in exercising the drastic power of arrest has been emphasized time and again by courts, but has not yielded desired result. Power to arrest greatly contribute to its arrogance, so also the failure of the magistracy to check it. Not only this, the power of arrest is only of the lucrative source of police corruption. The attitude of arrest first and then proceed with the rest is respectable. It has become a handy tool to the police officer who lacks sensitivity or act with public motive. Law Commission, Police Commission, and this court in a large number of judgments emphasize the need to maintain a balance between individual liberty and a societal order while exercising the power of arrest. Police officers make arrests as they believe that they possess the power to do so. As the arrest curtails freedom, brings humiliation, and casts scars forever, we feel differently. We believe that no arrest should be made only because the offense is non-bailable and cognizable and therefore lawful for the police officer to do so. The existence of the power to arrest is one thing, the justification for the exercise of it is quite another. Apart from power to arrest, the police officers must be able to justify the reason thereof. No arrest can be made in a routine manner on a mere allegation of a commission of an offense made against a person. It would be prudent and wise for a police officer that no arrest is made without a reasonable satisfaction reached after some investigation as to the genuineness of the allegation. Despite this legal position, the legitimate, despite this legal position, the legislature did not find any improvement. Numbers of arrests have not decreased. Ultimately, the parliament had to intervene and on the recommendation of 177th report of the Law Commission submitted in the year 2001, section 41 of the CRPC in the present form came to be enacted. It is interesting to note that such recommendation was made by the Law Commission in its 152nd and 154th report submitted as back in the year 1994. The value of the proportionality permits the amendment relating to arrest as the offense with which we are concerned in the present appeal provides for a maximum punishment of imprisonment which may extend to 7 years and fine. Section 41 1B CRPC, which is relevant for the purpose, reads as follows. Section 41, when police officer may arrest without warrant, any police officer may without an order from a magistrate and without a warrant arrest any person. B provides against whom a reasonable complaint has been made or a credible information. This is the important word. They have used the word reasonable before the complaint. Should be keep in mind by our colleague. Reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense punishable with imprisonment for a term which may be less than 7 years or which may be extended to 7 years, whether with or without fine if the following conditions are satisfied. Namely, the second provides that the police officer is satisfied that such arrest is necessary to prevent such person from committing any further offense or from proper investigation of the offense or to prevent such person from causing the evidence of the offense to disappear or tempting with such evidence in any manner or to prevent such person from making an inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the police officer, or as unless such person is arrested, his presence in the court whenever required cannot be ensured, and the police officer shall record while making such arrest his reason in writing. Then, provided that a police officer shall, in all cases where the arrest of a person is not required under the provision of this subsection, record the reason in writing for not making the arrest. Then, I want to basically correlate it with the constitutional goal. An accused arrested without warrant by a police has the constitutional right under Article 22, Clause 2 of the Constitution of India and Section 57 CRPC to be produced before magistrate without unnecessary delay and in no circumstances beyond 24 hours, excluding the time necessary for the journey. During the course of investigation of a case, an accused can be kept in detention beyond a period of 24 hours only when it is authorized. Detention is a very solemn function. Then it affects the liberty and freedom of the citizen and need to be exercised with the great care and caution. This is the most important thing, that the power to authorize detention is a very solemn function. It affects the liberty and freedom of the citizen and need to be exercised with the great care and caution. Our experiences tells us that it is not exercised with the seriousness it deserves. In many of the cases, detention is authorized in a routine, casual, and cavalier manner. Before a magistrate authorizes detention under Section 167 CRPC, he has to be first satisfied that the arrest made is legal and in accordance with law and all the constitutional right of the person arrested is satisfied. If the arrest effected by the police official does not satisfy the requirement of Section 41 of the Code, magistrate is duty bound not to authorize his further detention and release the accused. In other words, when an accused is produced before a magistrate, the police officer effecting the arrest is required to furnish to the magistrate the facts, the reason, and its conclusion for arrest, and the magistrate in turn is to be satisfied with the condition precedent for arrest under Section 41 CRPC has been satisfied, and it is only thereafter that he will authorize the detention of the accused. The magistrate, before authorizing detention, will record its own satisfaction, maybe in brief, but the said satisfaction must reflect from its order. It shall never be based upon the ipse dixit of the police officer. For example, in case of police officers consider the arrest is necessary to prevent such person from committing any further offense, or for proper investigation of the case, or for preventing an accused from tampering with evidence or making inducement, etc., the police officer shall furnish to the magistrate the facts, the reason, and material on the basis of which the police officer had reached its conclusion. Then, and the provision, that is Section 41 ACRPC, aims to avoid unnecessary arrest or threat of arrest, looming charge on accused required to be vitalized. Section 41A, as inserted by Section 6 of the CRPC Procedure Amendment Act 2008, Act 5 of 2009, which is relevant in the context, read as follows. Section 41A provides notice of appearance before police officers. The police officer shall, in all cases where the arrest of a person is not required under the provision of subsection 1 of section 1, the issue a notice, subsection 4, subsection 1 of section 41, issue a notice directing a person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the notice. Then, in this case, important thing is that एक जो routine manner का जो arrest का जो option था पुलिस का उसको रोकने की कोशिश किया through the Arnish Kumar judgment, and this is the reason why I wanted to share. Now, mm, uh, uh, this is the second last paragraph. All the state government has been instructed, and all the DGP and chief secretaries and DGP, they have got instruction by the honorable court that the police officer should not automatically arrest when a case under section 498A of the IPC is registered, but to satisfy themselves about the necessity for arrest under the parameter laid down above following from section 41 CRPC. All police officer is provided with a checklist containing a specific subclause under section 41 1B to police officer shall forward the checklist duly filled and furnish the reason and material which necessitated the arrest, with forwarding producing the accused before the magistrate for further detention. The magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officers in terms furnished, and only after recording its satisfaction, the magistrate will authorize detention. To the magistrate within 2 weeks from the date of the institution of the case with a copy of the magistrate, which may be extended by the superintendent of the police of the district for the reason to be recorded in writing. Notice of appearance in terms of section 41A CRPC be served on the accused within 2 weeks from the date of institution of the case, which may be extended by the superintendent of police and the district for reason to be recorded in writing. Failure to comply with the direction aforesaid shall, apart from the rendering the police officer concerned liable for department action, they shall also be liable to be punished for contempt of court to be instituted before High Court having territorial jurisdiction. Authorizing detention without recording reason as aforesaid by the judicial magistrate concerned shall be liable for departmental action by the appropriate High Court. We hasten to add the direction aforesaid shall not only apply to the case under section 498A of the IPC or section 4 of the Law Reprovision Act of the case in hand, but also such cases where offence is punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with fine or without fine. Therefore, जो हमारा आज का जो इशू था डिस्कशन का, evaluating law and policy in India from the lens of the 21st century. One, why I have discussed all these issues. जो पुलिस की जो एक व्यक्ति को अरेस्ट करने की जो एक पावर है रूटीन मैनर में, उसको अर्नेस्ट कुमार वाले जजमेंट के द्वारा उसको रोकने की कोशिश की गई है. नाउ इट डिपेंड्स ऑन आवर एग्जीक्यूटिव अथॉरिटीज हाउ दे आर implementing this particular case, but I would like to appreciate Honorable Supreme Court of India. They have taken into consideration these aspects which have put the common people in trouble. Even I have personally realized so many people have approaches me, and because I am we all are dealing with the advocates and with the common people, and it is a thing which I had tried to highlight in this HRDC FTP program, and how this particular judgment is relevant for all of us, and most important thing is that how Honorable Supreme Court of India has given direction to all the Chief Secretary and DGP and all the High Court, and they have put obligatory on the part of judges as well as the police officers. This was the thing which I had discussed. And then I had discussed the concept of victim compensation, how the victim compensation that is playing a pivotal role in the present scenario, section 357A of the CRPC, how this the concept of victim compensation has added, and basic object behind this victim compensation. Then I had discussed the concept of plea bargaining. I had discussed the object of plea bargaining. Even I had discussed the reason for the for not so successful of this concept. Then I discussed the principle of fair trial, principal features of justice delivery system. Then I had discussed some introductory part of for the CRPC, IPC. I would like to say thanks to HRDC Gujarat University for giving me this opportunity. And I would like to say thanks specifically Dr. Bhavesh Bharat sir for his approach and commitment toward his own institution. Even I'm telling you that I should try to learn from Dr. Bhavesh sir that how he is so committed. Even he tried to uh, remind all of us that you have to give this particular recording from so many days. Thanks again for inviting me. Jai Hind, Jai Bharat.